I think both the 1102 statement that we intend to introduce and sort of referred to the video. So let me address each of those one at a time. With regards to the 1102 statement that was prepared by Ms. Wright, Judge, it was gathered in compliance with the Utah Rules of Evidence 1102, specifically subsection B8. It's a statement that was gathered by an SBI agent. It was prepared with knowledge of the advisory that it was going to be used at the preliminary hearing, and it also included the warning that if a false statement is given, it's going to be a Class A misdemeanor. Judge, I don't know what additional foundation you'd like. Well, that's kind of where I was going, Judge, is I was trying to lay a little bit more foundation just to introduce that statement alone. I haven't got yet to the video. But with regards to the 1102 statement, it has been collected in compliance with Rule 1102. As I stated, B3 or B8. As we all know, Rule 1102 allows reliable hearsay, as does the state constitution, Article 1, Section 12.
So what exhibit will this be? I want to look at it not for the purposes of, as a magistrate, taking it into evidence, but see if it comports with Rule 1102 as stated, because I haven't seen it.
Sure.
And I haven't done the analysis to see if that objection is.
Judge, it is State's Exhibit 6.1.
And Your Honor, just for the record, we just want to make a record too that it's difficult for the court to make a reliability finding when the individual is not here to be tested and cross-examined, and for those same reasons that we list in our standing objection, we just want to reiterate to the court that we think it really hampers you from making that reliability determination.
Thank you. Anything further, Mr. Sturgill?
Well, just that 1102 doesn't require that, Judge. It doesn't require that the witness be here to corroborate the statement that they've already prepared.
All right. All right. I've had a chance to review State's Exhibit 6.1, taking into note what Ms. Nestor noted, UCJA 4-202.02 and referencing the section she did.
Well, and Judge, I don't mean to interrupt, but I had not yet addressed that rule. I would simply just add to that judicial rule, it has nothing to do with admissibility. It's simply publishing it.
Right,
and I'm sorry.
So, okay, so let me just hear your full argument.
Yeah, I didn't realize you wanted to hear all of it. I thought you were going to rule on the 1102, but.
Well, I want to focus on the 1102. I want to keep this clean. So let's focus on the 1102,
right.
and we'll stop there, and I can make my ruling. And then if there's any objections, I just need to take it one step at a time to be thorough. So I'll hear all your arguments about the 1102 statement. I'll return to Ms. Nestor for any final thoughts, and then I'll make my ruling, and then we can move to the next stage.
I appreciate that.
Yeah, defense is trying to do anything at this point, you know, to try to hurt, or well, try to stop the testimony here from the lead investigator.
Judge, and I think I think I have addressed the 1102 question as far as admissibility under Rule 1102. I thought that's what you wanted to rule on first, and then I would address the UCJA 4-202.02. And if you want me to do that now, I can do that. And it's just simply that it has nothing to do with admissibility. It has everything to do with publishing that. And Judge, I think if you'll look at that written statement, I believe Ms. Wright's personal information, for the most part, has been redacted. Other than that, and beyond that, Judge, I'll leave it up to your discretion.
Well, as it relates to, well, let me take it one at a time. Let's start with the last statement. What I have in front of me, Plaintiff's Exhibit 6.1, has her full information here: address, phone number, social security number.
Okay, Judge, I apologize for that. I thought we'd provided a redacted version of that. Yeah. I think I've clarified what's going on here. I think we provided you with an unredacted version some time ago. The version that we have and are prepared to present today is a redacted version.
Could I have a copy of what you're intending to admit into evidence so I can consider what's before me?
Yeah. Judge, we can bring it up electronically. We don't have a hard copy of that.
All right, I want to make sure that's not coming on screen. It's just coming
Yeah.
on my screen to review it. All right. Okay, no, and that's fine. It's not, it's just for my, that I can look it on my screen because I'm trying to evaluate, so if you just want to put it back on my screen.
It's on all the screens now.
All right, well, so what I'm doing is I'm looking at this, and just for clarity, moving forward, if there is a particular exhibit, I'll ask that you provide it instead of me relying upon it here, just so there's no misunderstanding, and I can see exactly what is being moved into evidence. I don't want to assume,
Right.
and I want to do the proper analysis. All right, so
And I appreciate that, Judge, and I apologize. I understood that we were presenting redacted copies today, and
Okay.
I think there's
No,
just been
that's
a little bit of a glitch, so I apologize for that, Judge.
all right, and Ms. Nestor, I just want to make sure that you're looking at this exhibit as opposed to what I was just looking at in regards to your arguments. With this clarification in mind, any update to your argument or anything that you would like the court to consider?
The only other issue I think that exists with this that I haven't already raised is that there's clearly two different authors in the body of the document. One wrote something on the very top line, and then it looks like Ms. Wright wrote the rest of it,
Scroll down.
which we don't have any indication of who wrote that top line and when they filled that in, if it was before or after she signed the document. So I have some concerns about authenticity with respect to that as well, and that's all I have.
All right, and as I'm determining it, it does appear that the writing is different. Did you want to lay additional foundation, Mr. Sturgill,
Certainly,
or
Judge.
provide information for the
I'd
court?
be happy to do that. Do you have in front of you State's Exhibit 6.1?
I do, yes.
Okay. You've heard the discussion that just took place. It appears as if there's two different styles of writing on that form.
Yes.
Okay. I imagine that you have the writing that includes the personal information for Ms. Wright, and then directly below that, I think there's a line there that appears to be arguably writing prepared by someone else. Is that in fact accurate, that is a different
That's correct.
author of that writing? What do you know about that writing on that first line just below statement of incident?
Because we were asking Ms. Wright to verify a specific video, the file name for that video was written on the statement in her presence. And then that video with that file name was then shown to Ms. Wright to verify that it was, in fact, the video that she had provided to us.
Okay. And so was it you or SBI agent Davis that prepared that?
Based on the writing, it appears to be Agent Davis's writing, but it's not my writing.
All right. But that is the routine, or is that kind of how you commonly do this?
In this case, because we were specifically asking them to verify a specific digital file that had a specific digital name, and we didn't want there to be any errors in how that name was presented, we wrote the file name on the document for the individuals.
Okay.
All right. Anything further, Ms. Nestor, with that additional information before the court makes its ruling?
Your Honor.
All right, thank you. And could you leave that on the screen for me, please? I appreciate that. And scroll down to the bottom. I just want to review it one last time. All right. And I believe this is Exhibit 6.1. Is that correct, Mr.
It is,
Sturgill?
Judge.
Right,
I would move to admit 6.1.
Thank you. So considering the arguments made by Ms. Nestor and Mr. Sturgill, I rely upon Rule 1102 as well as Utah Constitutional Article 1, Section 12, as I previously mentioned. That final paragraph, it states, nothing in this Constitution shall preclude the use of reliable hearsay as defined by statute or rule in whole or in part at any preliminary examination to determine probable cause or at any pretrial proceeding with respect to release of the defendant if appropriate discovery is allowed as defined by statute or rule. I have examined this, and the clarification was made. The previous version of this would fall afoul of having identifiable personal information of Ms. Wright, and so that was removed. And this one, with the redacted portion of the
Guys, I'll explain what's going on here in a second.
identifiable information, personal information for Ms. Wright is before me. And based off that, State's Exhibit 6.1 with redactions is admitted into evidence and may be published.
Thank you, Judge. Agent Hold, that statement that was prepared by Ms. Wright, what does it state with regards?
Okay. Here's what's going down. Let me boil this down for you guys real quick. Right now, for all you guys, because we're live on TikTok and YouTube, I'll bring you guys up to speed very quickly here, okay? Basically, here's what's going on. The lead investigator for the SBI is on the stand. This is the case agent. This is the guy that ran the investigation. This is probably one of the most important law enforcement witnesses for this investigation. As lead agent, you are responsible for dealing with the prosecutors. You're responsible for liaisoning with other agencies. You're responsible for writing the reports, talking to key witnesses, gathering evidence. You are the presenter of this case. Now, I do think it's important that you guys understand that the lead investigator is no longer with the SBI. He went off and did a more cushy detail being like a trainer. So that should tell you that this case probably stressed him out. He said, I'm out of here. Okay, I thought that was very interesting that he's no longer with the SBI Major Crimes Unit. He left. Now, with that said, the reason why, and I predict here what's going to happen is the defense attorney is going to grill him pretty hard and the other case agent very hard. There's two guys on it. This guy was the lead, and then obviously in the beginning of the investigation, he probably obviously left, turned it over to the other guy. He's the second lead and probably like the lead at this point. But when the case began, when they arrived on scene, they were supposed to go and give some assistance. They ended up taking a case. Now, this is very common where if you got like a local police department that's overwhelmed, that can't handle this, like University Police Department, for example, where you got like a couple of cops, maybe 10 cops, and like 2 detectives, they don't have the capacity to handle this. So the state police will often take it. And that's what's happening here. They took it. So obviously this is a very important witness for the state. That's why the defense is trying to hit him on hearsay. Now, again, this is a preliminary hearing. Hearsay is admissible. This is not a trial. Okay? Hearsay is basically like testimony that comes from other people and not the direct individual. In trial, we need to bring that witness in. If this was a trial, they would have to bring that witness in that recorded the footage that they're talking about right now. But since hearsay is admissible, they can do that. Now, what the defense tried to do was, it seemed like there was a sworn statement, and the defense was like, well, you know, she's not here. There's some issues here, blah, blah, blah. So that's what they were fighting about a second ago. So now the prosecutor's going to kind of like ask the question another way. Give me a 1 in the chat if that makes sense. Give me a 1 in the chat if that makes sense. And we'll get right back to it. I hope that kind of explained what just transpired there.
To the video that you showed her that day, or I guess Agent Davis showed her that day.
Someone said what happened. Dude, I literally just explained it. Just rewind the video.
It states that she's confirmed that she did review the video and that it was a true reflection of the video.
Okay, here we go. Statement of incident. Oh, what you know about this incident. So they put the video. Okay, so I get it. They put the video file here because they know what they're referring to. She's not going to know it. Look, there's a case number right there, 2025-09110, 910, and then underscore something, blah, blah, blah. Yeah, they put this here so that they can, like, file it in their records. Then here's her statement after. So, yeah, the defense attorney's just grasping at straws, bro. Yeah, there's nothing wrong with writing on the top what it's going to be. They labeled what it is. Now, if they really want it to be official, you can initial it, right? What I would have done, I would have initialed it, Special Agent Amber Fotto right here, so they know that I wrote that in and then she initials her comment. But, you can see it right here that she signs at the bottom.
That she took on September 10th, 2025.
And did she identify who's in that video in her statement?
Herself and...
All you guys that are watching on TikTok, do me a solid, guys. Double tap the screen. Hope you guys are enjoying the broadcast. You guys are not going to get better coverage on this than anyone else. So make sure you share the broadcast, double tap the screen, and just, YouTube guys, like the video for me.
Her 2 young children.
If we could just have a clarification on the court's ruling. So I understand the court.
I think this witness, Wright, probably provided some very important footage, which is why they're bringing it up.
Overruled and published, and I accept the ruling, but I thought under the court's previous order that the media was not going to film exhibits.
Oh, she's not happy because they showed it.
And they are filming the ones that are on that screen. So I guess I just need to clarify that, Your Honor. I'm sorry.
No, and I appreciate the clarification. It's important. What my ruling when we came back from break was if you are objecting specifically to the exhibit and then to the exhibit being published in the courtroom and then the exhibit being published, which can be captured by media, if that's not specifically addressed, I am going to allow it. So I didn't hear a specific objection to that. So I appreciate you bringing that up, but that's how I'm looking at every single objection, just for clarity of the record.
Thank you, Your Honor. So just to make sure I correct the record, we are objecting to the publication of this under the UCGAA rules for the reasons I said, but I respect that you've ruled on that. And in the future, I guess we'll just make particularly clear we're objecting to publication because I do think anything that's getting on that screen is getting filmed.
Okay.
So thank you, Your Honor.
Thank you, Ms. Nestor. And
Oh, yeah, they definitely filmed it. KSL News Utah got it.
Mr. Sturgill, did you want to respond?
So, yeah, the guy on the stand right now, guys, is David Hull. That's the guy that's lead investigator right here with the Australian accent. I don't know if you guys peeped it, but he said he did alcohol for a while. He probably worked like for the alcohol compliance people. He probably did undercover because of his accent.
I mean, it's the genie's a little bit out of the bottle on this particular issue, but any record you wish to make.
Judge, we're simply going to seek to admit each one of these exhibits, and then we're going to leave it up to Your Honor's discretion whether to publish them beyond, well, to what extent you want to publish them.
All right. Well, I would prefer argument on this issue from both sides. I don't. This is the burden of the state, so I don't want to exceed my lane by just assuming. So I'll leave it to you to make the argument. What you're requesting.
Sorry about that.
So before you're moving on, Mr. Sturgill, as it relates to
yes.
this, I want to put this to bed and then we can move on. Were you requesting for it to be published on so the three? You moved it into evidence, which I approved. It is moved into evidence, but I didn't hear anything in regards to publishing to the courtroom, and then lastly publishing, which it would be captured by the camera in the background. In the back.
Judge, we believe these are public documents, and so we would ask that they be published both to the audience and to the public at large.
All right. Well, given that we've gone past the gate on this one,
Right.
It's been published.
Right.
But I think we're all on the same page in regards to how objections may be made and how the court is going to consider it, so we can move forward. All right. Thank you, Mr. Sturgill.
Thank you. Have you personally watched Ms. Wright's video?
I have, yes.
Okay. And what is depicted in that video?
It's a view of Miss Wright's position in the crowd at the event on September 10th.
And there you go. It's critical footage. Probably one of the best vantage points.
Okay. And
That's why they're using it.
Absent the written statement from Ms. Wright, can you at least recognize the location that's displayed or depicted in this particular video?
Yes, it's the amphitheater at the Utah Valley University where Mr. Kirk was doing his event.
Okay. On your screen, Exhibit 6. Do you see anything on your screen yet? Just the very beginning.
It's there now.
It's there now. Do you recognize what's depicted on your screen right now?
I do, yes.
And what is that?
In the background is the Hall of Flags, and then you have the gazebo under which Mr. Kirk was presenting his event from, and then the crowd between where Miss Wright was and the stage.
Okay. But do you recognize what this is the beginning of?
Yes, this is the
All right, for all you guys that are just joining, lead investigator is on from the State Bureau of Investigation from Utah. This is the lead investigator. Okay, what is the SBI? The SBI is the FBI equivalent for the state of Utah who handles major crimes. Okay, the guy's name is David Hull. Okay, special agent with the SBI. He is the one that's testifying right now.
beginning of Miss Wright's video.
Okay.
In a preliminary hearing, this is not the trial, chat. I've seen a couple of you guys in the chat say it's a trial. It's not a trial. This is a preliminary hearing. It's only to establish probable cause.
Judge, the state would move to admit what's been marked State's Exhibit 6.1.
If you're watching on YouTube, smash the like button. If you're watching on TikTok, smash the double tap. Okay?
Oh, I'm sorry, 6. I apologize.
And to what level?
Your
Hold
Honor.
hold on, Ms. Nestor. I just want to get the clarification, and then I'll certainly turn to you. So the levels of admitting into evidence, then the next level is publishing it to the courtroom, and then the next level is publishing it in a way that is captured
Yeah, share the live, guys. Appreciate you guys on TikTok sharing the live.
by the media. What is your full request?
Judge, we'd ask that, first of all, it be admitted, that it be published
Andre Kick, thank you.
here within the courtroom, and then that it also be published to the public at large.
All right, and I'm not quite sure what this particular video is showing. Could you lay a little bit more foundation or proffer that what this is?
Sure. You've seen this video, Agent Hall?
Correct.
What's depicted in this video?
The crowd and the beginning of Mr. Kirk's presentation to the audience in the amphitheater at UVU on September 10th, 2025.
Okay. Does it depict Miss Wright?
I believe towards the end of the video it scrolls back and Miss Wright shows the people that she's with at the event and herself, yes.
All right, is there any act of alleged violence in this particular
No, there is
clip?
not, Judge, but there is not.
Okay, I just needed that clarification. Ms.
Right.
Nestor, I'll turn to you. I just wanted to make sure I understand the full scope of this exhibit and then hear from your objection. If
Southern Mom, thanks for the roses. And shout out to all you guys that are showing love. Yangalang, Southern Mommy, Tennessee Creek, top 3 showing love. Ophelia Hudson, shout out to all you guys showing love on TikTok. I've been gone for a long time. I can see you guys miss me. 6 years banned. In the shadow realm.
if any.
But I'm back.
Your Honor, with respect to admission, we object to its admission on the grounds that it's not properly authenticated, as Ms. Wright herself is not present in. For all the constitutional reasons we raised in our standing objection, we object to that. As far as its publication, we object to its publication. It definitely is something that
If you OSS guys are watching on TikTok, let me know. I'll mod you up right away. Any OSS guys watching on TikTok, let me know and I'll mod you up.
in its current form without her here would not be admissible in any place other than a preliminary hearing. And we feel like this would really
But say it in the OSS chat. Give me your TikTok name on the OSS chat so I know you're actually in the OSS. I'm looking at the OSS chat right now.
impinge on Mr. Robinson's right to a fair trial. And so we're asking it not be published. And certainly, if the court does publish it, that it certainly not be filmed.
Thank you. Mr. Sturgill, any response?
Judge, Rule 901 addresses authenticating or identifying evidence to satisfy the requirement of authenticating a document, or I guess authenticating a piece of evidence. The proponent, which in this case is the state, must produce evidence sufficient to support a finding that the item is what the
All right, all you TikTok guys, type in a TikTok chat so I can start giving y'all wrenches. So I'm gonna look at my OSS chat, then I'll look at my TikTok chat, and I'll give y'all wrenches if it matches up, because you know people are gonna try to scam.
proponent claims it to be. And then the rule goes on to explain or provide examples of how this rule can be satisfied. And at the very top, under subsection B1, is testimony of a witness with knowledge. That goes on to say that testimony that an item is what it is claimed to be satisfies this authentication rule. Judge, you have an 1102 statement prepared by the person who actually caught these images on her camera or on her phone. And so, Judge, I think that alone sufficiently authenticates the document. And then even further than that, you have Agent Hull, who has reviewed the video himself and authenticates it, at least with regards to location.
Thank you. As it relates to admissibility of this exhibit, I believe this is State's Exhibit 6. Is that?
It is, Judge.
All right.
Your Honor, I'm sorry to interrupt. Can I add one more thing just for the record? For purposes of publication question, under UCJA 4-202.02, parent 4, parent R is in Richard, photograph, film, or video of a crime victim are designated as private court records. And I do think that based on what the state has previously referenced, they are perceiving that everyone in the audience is a potential victim, and so we think it shouldn't be published under that rule.
Thank you. Mr. Sturgill, on that final point.
Judge, I appreciate that argument from Ms. Nestor. And we don't necessarily disagree, but to that end, to protect who we believe is a victims in this video, I believe their faces have been blurred out.
Oh, I see. Ms. Nestor, have you?
I think it's only the minor children whose faces are blurred out, not Ms. Wright, if I'm not mistaken, unless it's been subsequently altered.
My recollection is they've all been blurred out.
All right. I need to view this again. So let's just put it on my monitor. Again, I'm just trying to make sure that in order for make a ruling on this, I need to view it. So let's put it on my monitor, play it without any sound. Okay, my understanding is the prosecution has control of this exhibit. So what I'm asking is that the sound be turned off, if there is any.
OSS guys, keep putting in your thing so I can give you guys mods.
And just go ahead and play it, and it's only on, well, it's on all the parties' monitors, because I want you all to view it, because that can go directly to, as you've mentioned, Ms. Nestor, whether it's possibly admissible. So let's go ahead and play that.
Yeah, Tyler Robinson is balding, chat. Bro's been stressed. Guys, I'm only giving wrenches to OSS guys. That's it. I'm not giving wrenches to anybody unless you're an OSS, bro. We are outnumbered on TikTok. We are outnumbered on TikTok, so I'm only giving wrenches to base dudes, man. If you want to join OSS, it's only $1 to join, $10 after that. Jump on in. I could drop the link in there. Use the code LYouTube.
All right. Thank you. Based off what I've watched, there was some blurring of faces, but not of all the faces, and so I'm going to rule that it is admissible. Sure. I'll wait until all parties are ready to proceed.
Someone said, do I stream a lot on TikTok? I'm gonna. I just have to keep it clean when I'm on here.
So anything further? I just want to make
No,
sure.
Judge, you got a chance to watch that?
I did. So I'm ruling that it is admissible into evidence, again, taking into consideration the analysis.
Yo, OSS guys, keep typing in the keep typing on the TikTok, dude, so I can find you guys. Crash Out Martin, you already got him. Yeah, I already gave you a mod. Salah, I gave you one already.
The court's talked about in regards to 1102s and this particular piece of evidence as it relates to the 1102 video, the 1102 statement 6.1, and I'm going to allow it to admit it into evidence. And because the faces of the alleged victims are not all obscured, there are some that are visible, it's not going to be published to in-court monitor and obviously not to be filmed by the media. So the court will receive it into evidence. The court will watch it again right now, and then we can continue to proceed.
Very good. Thank you, Judge.
So if to the state, if you would like to play it again for me.
I dropped the OSS link for you guys in there. Just use the code LYouTube as $1 for the first month. Best way to support the mission because I'm demonetized on YouTube.
I'm viewing it as it relates to consideration as the magistrate.
Your Honor, sounds like an issue that's going to come up again. I represent the news media. Can I be heard on this issue?
Yes.
Dominicano, you got your wrench. Josie, you got your wrench.
I just wanted to address it. I've tried to be quiet. I just wanted to address it now because it's going to keep coming up, it sounds like. The classification rule that Ms. Nestor is citing and that Your Honor was just reading is not about in-court exhibits. That is classification for records in the court file. So it is a fundamentally different thing when we are in a public proceeding and the state is presenting an exhibit that you are relying on and the public is being denied the chance to see it. That is a fundamental violation of the right of access. And it's a qualified right, and I recognize that. But that's not the ruling that you just made. You're just ruling based on the Code of Judicial Administration, which doesn't have anything to do with when something is presented in a public proceeding. So while I recognize there are certain things where I understand that you were going to make an exhibit-by-exhibit evaluation based on certain exhibits that may, be somewhat, may cross the heavy threshold of being so prejudicial that they cannot be shown in public. That is not this. And so I just wanted to make clear that the things that are in Rule 202 are not, when it is presented in open court as an exhibit for you to rely on, the public is entitled to see what you're seeing so that they can understand what your decision-making process is. And so this one, it doesn't sound like, this sounds pretty anodyne to me. It's not even depicting the shooting. I just wanted to clarify that the classification issue about when, we're filing things with the court and we say like this, maybe we file a motion to classify. That's not the decision that you're making today. The decision you're making today is the state is presenting something to you. You're watching it. You're making a decision based on it. And the people in the gallery have the right to see that. Whether you allow EMC of it is a different question. And we think that the EMC should be allowed to for reasons that we briefed. But I do think that it at least should be published to the courtroom.
Thank you.
Thank you, Your Honor.
To the parties, do you wish to respond?
Shay, you got your wrench?
We'll submit it. Well, Judge, I'm sorry.
Oh, hold on. Okay, so we'll go to Ms. Nestor first
ahead.
and then to the state. Mr. Sturgill.
The only additional observation I'd make is with regards to this video and this video only, the state doesn't believe that the defense really has standing to make an argument on behalf of the victims in this case.
All right. All right, based off of what's been presented in recognizing the argument from the media, I see the differentiation and how they are differentiating the rule that was cited versus what was presented. So I'm going to go ahead and rule that this may be played in the courtroom but not be captured on video. So to the camera operator, I just want to make sure that it's going to be playing on that, but I don't want it captured. I appreciate the patience of the parties as we're going through the many layers that need to be addressed.
Okay, I passed out a bunch of wrenches, man. You guys should be good. I passed out a bunch to the OSS ninjas, man.
On exhibits such as these. So we'll go ahead and, once that's ready to be played, let's go ahead and do that.
That's a lot of people you saw. I'll tell you what. Order. Everybody, you know how it works.
Thank you, and that concludes Exhibit 6.
Correct. Thank you.
Mr. Sturgill, you may continue.
Agent Hall, did you or any other SBI agent collect additional video?
Yes, there were other videos collected.
What additional video did you collect?
A cell phone video from Mr. Phillips was collected.
And do you know who or how that video was collected?
Yes, Agent Schultz made contact with
I clicked a bunch of you guys and gave you guys wrenches. I mean, it should work. Maybe refresh your page.
Mr. Phillips September 29th of 2025, and that video was provided to him. Subsequently, in preparation for the proceedings today, myself and Agent Davis met with Mr. Phillips on April 6th, and he completed an 1102 and went through the same process as Ms. Wright. The only difference being on this occasion that because he is a minor, his mother witnessed it and also signed a statement.
Okay. So you personally reviewed Mr. Phillips' video with Mr. Phillips?
Correct.
Okay. And you had him prepare a written statement?
Yes, correct.
Again, on this written statement, are there two different authors?
Yes, I believe in this instance it was myself that wrote the file name on the form.
Okay. And so you wrote, what part of the statement did you write?
Just the name of the file that we were asking Mr. Phillips to verify.
Okay.
Yeah, that's for their own like tracking purposes. Completely normal.
I have exhibited on your screen was been marked States Exhibit 7.1. And this should just be for Agent Hall.
That's on my screen.
Is it on your screen? Do you recognize what that is?
I do, yes.
What is that?
The State Bureau of Investigation 1102 form completed by Mr. Phillips.
Okay. And did you gather that from Mr. Phillips?
I did, yes.
And again, does this statement include the advisory that is going to be used in lieu of his testimony at prelim?
It does.
And does it also include a warning that if he makes the author makes a false statement that could be punishable by being charged with a Class A misdemeanor?
It does, yes.
Okay. Anything about this exhibit look different than the day you collected it?
No.
Does the state would seek to admit Exhibit 7.1?
Ms. Nestor?
Thank you, Your Honor. We would object to the admission on the grounds that this video does in fact show a close-up view of the shooting of Mr. Kirk in grievous injuries in very stark relief. And because of that, we are particularly concerned about our constitutional claims we have made in our standing objection in terms of our ability to get a fair trial. If this is
So they don't want to show the video. Guys, refresh your page. Hopefully you should have your wrench. Refresh your page. Hopefully you get it.
published, and I think, again, we have the same issue with the court, being in a position where you're having to make a reliability determination without the opportunity for this individual to be cross-examined. Also, I do think the fact this is a minor that completed this form does make it protected. He's also potentially a victim under the same theory that has been stated for Ms. Wright, and under the UCJA acts for the same reason, the UCJA rules for the same reason, these should be protected private court records, and private means it shouldn't be played to court and it shouldn't be played to the public through the media. So we would object to its admission, we would object to its publication, and we would object to its filming. Thank you.
Any final response?
Judge, let me address, well, there's two things here, right? Let me address first the 1102 statement. Judge, I believe again that this statement was gathered in compliance with Rule 1102B8. Just double check. And the agent has explained that although Mr. Phillips is a minor, his mother was present, and that explains, I believe, he said the second signature on the form. With regards to publishing it,
Yeah, that's one way to get it in. Get the parent permission.
the 1102 statement, that is, Judge, we believe again, the presumption is this is a public record, and that it should be not only admitted but published here in court and also published so the media can record it. With regards to, well, do you want to address the 1102 and then I'll move on to the video?
All right, so we're staying focused on the 1102. Any final response, Ms. Nestor?
No, Your Honor.
All right, thank you. As it relates to the 1102 statement and to the state representative who is displaying it, could you scroll down? I can only see the top half of this. All right. And just go to the very bottom.
Yeah, guys, I'm trying to mod you through my computer. It's not, I don't think it's letting me do it, man. I don't know why. Oh, man. Let me see if I could do it on my phone.
So I can look at the totality of it. This is 7.1. All right, based off what's before me on the State's Exhibit 7.1, I find that it is admissible under Rule 1102 and to the Utah Constitution, Article 1, Section 12, to that paragraph I have referred to previously, and so it is admitted into evidence. And Mr. Sturgill, remind me, were you requesting for it to be displayed? I'm, again, focusing on 7.1.
Right.
In
On
court.
7.1, Judge, with regards to the video, we believe it's admissible. It's been authenticated properly.
Hold on. I'm not talking about the video. I'm talking about 7.1,
Oh.
publishing it in the courtroom versus publishing it on to be captured by the media.
Because we think that the presumption is that it is a court record. We believe that in its redacted form. We believe it should be published in all three areas.
All right, Ms. Nestor, any final thoughts?
No, Your Honor.
All right. I'm going to go ahead and grant the publishing of Plaintiff's Exhibit 7.1 in court and that the media may capture that. Let's go ahead and do so.
All right. Let's see.
Slowly scroll down.
So here's the document. U.S. Department of Public Safety, voluntary statement affidavit. So this was sworn statement taken in April of 2026. So Image I have viewed, blah, blah, blah. Looks like this is the parent right here, Jennifer Phillips. Ty Phillips.
All right. You may proceed.
Did you admit Exhibit 7.1?
It is admitted into evidence and it was published.
Have you personally watched Mr. Phillips's video?
I have, yes.
Okay. And what does it depict?
It's a graphic video. Mr. Phillips was positioned towards the front of the crowd, and it does depict the moment that Mr. Kirk is shot.
Okay. And independent of the 1102 statement prepared by Mr. Phillips, you watching that video, do you recognize at least the location of this video?
I do. It's consistent with the event that Mr. Kirk was presenting at UVU on September 10th, 2025.
Okay. Just at this point, the state would move to introduce, or would move to admit what's been marked State's Exhibit number 7. We would simply ask that it be admitted. We would ask, however, that it not be published beyond that,
Ms. Nestor.
due to the graphic nature and the sensitive nature of the video.
All right.
So as to the admission, the same issues that we raised as to the 1102, we would raise as to the difficulty
Yeah, defense really doesn't want this video getting in, chat. That's what they're arguing about all this time, is basically they don't want this video getting in,
of authenticating when the individual is not here
at least for the prelim hearing.
present, and all the same concerns that we
And
raised
they're using the excuse that the defendant isn't, sorry, the witness isn't here to testify to it, so they're trying to keep it out.
about the 1102 itself, Your Honor.
Thank you. All right. Considering the,
I'm sorry, may I add one more? I apologize. And also under Rule 403, we think it's more prejudicial than probative, and we would raise it for that reason as well.
any final response, Mr. Sturgeon?
No, Your Honor.
All right. And this is Exhibit 7, is that
7,
correct?
Correct. Exhibit 7, Judge.
All right. I will admit Exhibit 7 into evidence based off the foundation that's laid. The 1102 is tied directly to this, and so for admission purposes, it is admitted. I am not going to authorize publication in the courtroom or obviously through media, but I will have it played on my screen. And so I view it, and I just want to make sure, and please, counsel, given the graphic nature of it, please guard your screens because I believe we all should be viewing this.
Okay, Chad, I think I found a way to do it. So this is what I want you guys to do on OSS. If you're on OSS, send a $1 super chat, guys, just so I don't lose your name with your username on TikTok. If you already did it, don't send another one in. I'm going to go through. I'm going to find you. I found how to do it on my phone. I'm going to add you manually. Just give me your TikTok username, and I'm going to compare it with the OSS super chats, and I'll add you in for TikTok. So you guys can go in there and moderate, okay? I got you on ninjas. If you already donated, don't donate again. This is only so I can keep it organized and I can find you guys.
This is evidence, and I want to make sure that you all are seeing what I see to ensure that that is accurate and it's a fair representation of the exhibit that you are familiar with. So whatever you need to do, I'll give you a moment, and if you could just give me a thumbs up if you're ready to proceed. Again, I want to act in a way that is dignified in respecting the rights of all persons. And for those reasons, I just want to make sure we are safeguarding to ensure this is not captured. All right. To defense, ready to proceed? Yes, Your Honor. All right. To the state? Yes, sir. All right. Go ahead, and let's play Exhibit 7. Is there sound? There is, Judge. All right, let's make sure that, thank you.
Okay, so they're not going to show it, obviously, because the graphic nature of it.
We don't know how, we don't know what they did. And for those
Impulse.
Yeah, Mr. Farnsworth originally provided, I believe, a flash drive to Lieutenant O'Brien with one of the local agencies. And a short time after that, on September 10th, he provided downloadable versions, electronic versions to Agent Mortensen. And an 1102 was collected from him on May 6th of 2026.
So an 1102 was prepared by someone with visual impulse?
Yes, Terrell Farnsworth was the individual that prepared it, and in preparation for this, I spoke to him personally regarding that statement.
And do you know what his association is with visual impulse?
I believe he's the owner-operator or the director of the company.
And then who collected that 1102 statement from Mr. Farnsworth?
It was Agent Mortensen who collected it.
Okay, and you know that because Agent Mortensen told you, or
He
something?
provided it to me, and then, as I mentioned, I subsequently spoke to Terrell Farnsworth personally regarding his statement.
Okay. You had a chance to look at Mr. Farnsworth's 1102 statement?
I have, yes.
Okay. And again, does that statement include an advisory that any statement that he provided would be used at preliminary hearing in lieu of his live testimony?
Yes.
Did it also include a warning that a false statement would potentially be punished by a Class A misdemeanor?
It did, yes.
Okay. I'm going to have exhibited on your screen what's been marked State's Exhibit 8.1. Let me know when that comes up.
That's come up.
I think it's a single page, is it not?
I believe it is.
Go to the top screen. Scroll down slowly. Can you see that, Agent Hall?
Yes.
You do recognize that?
I do, yes.
Okay, and again, that is what?
It's the 1102 statement that was provided to me, completed by Mr. Farnsworth from Visual Impulse, who is the videographer for TPUSA for the events that they do.
Okay. Judge, the state would move to admit State's Exhibit 8.1.
Ms. Nestor?
Thank you, Your Honor. At this point, we renew our objection. This is hearsay. This statement is hearsay. We have constitutional concerns for the reasons we raised in our standing objection. We also would like to cross-examine Mr. Farnsworth about whether or not and to what extent these videos may have been altered in any way. It is clear that clips were being made out of the larger videos because he sent, even his own statement says he sent larger videos, and this is just a small portion of them. So obviously someone made clips, and we don't know who, and we don't know how, we don't know what they did. And for those reasons and the reasons in our standing objection, we would object to the admissibility of it, and as well the, I don't have a redacted version of 8.1, but I assume there is one. There is personal information on this one. Do you have a redact? Okay, I don't have that one. All right. And we would object to publication just on our concerns for fair trial, the same issues. Yeah, gotcha. Yep, I think so. Thank you. And for all those reasons, we would object to its admissibility, its publication, and its ability to be filmed by the media, Your Honor.
Ms. Nestor, I just wanted to check, did you get a copy of the redacted?
I was just handed it.
Okay, I just wanted to make sure that
right.
you had copies.
Thank you, Your Honor.
So, okay, thank you. Mr. Sturgill, would you like to respond?
Sure, Judge, thank you. With regards to the admissibility of the statement, Judge, I think the foundation has been laid that this statement was collected in compliance with Utah Rule of Evidence 1102, subsection B8. It constitutes reliable hearsay. It's a statement that's been made by a declarant that's written, and it's under oath, or not under oath, but pursuant to a notification of the declarant that a false statement made is punishable. I think there's been foundation to support that. In addition, Judge, Article 1, Section 12 of the Utah Constitution makes it very clear that the state at preliminary hearing can rely upon reliable hearsay.
All right. Anything?
I'm going to tell Brett to mod some of you guys, man, because it's taking too long. And TikTok is not fucking helpful at all with this crap. It's very annoying. When I search some of your guys' names, you guys just don't come up.
Anything further before I make my ruling? Thank you. All right, applying the same analysis from the previous exhibits as it relates to the written statement under Rule 1102, and also under the Utah Constitution, Article 1, Section 12, in that last paragraph, I will overrule the objection and admit State's Exhibit 8.1. Let me hold off.
Hey, smash the like button for me on YouTube, by the way, guys. Smash that like button for me.
On that final phrase, if you could scroll down to the state representative and just...
I'll give you all like another minute, but smash that like button on YouTube.
Stop right there. Thank you. I just want to make sure I fully review it before I make that ruling. And if you could continue.
Your Honor, we would just renew our objections to authentication for admissibility purposes under 901
Bro, this is hilarious. Every objection is on hearsay
and the 1102.
in a prelim hearing.
You know, someone prepared these clips. We don't know who. We don't have that person here to cross-examine in terms of what, if anything, was edited. And for that reason, we think it can't be authenticated, and we object to its admissibility and our standing objection for constitutional grounds.
Thank you. Just one moment here.
Judge, would you like me to respond?
Yes, please.
Just with regards to authentication, again, the state must produce evidence sufficient to support a finding the item is what the proponent claims it to be. And again, under subsection B1, it's sufficient to provide testimony from someone that has firsthand knowledge or observed, has firsthand knowledge regarding the authenticity of that video. You heard Agent Holt testify that he spoke to the owner of and the director of Visual Impulse, I believe.
Hey guys, double tap the live on TikTok. Double tap the live on TikTok. What do we rank right now, guys? On TikTok live, what do we ranked? I see Dean has the most with 27.2, but this is like his main platform. What do we rank right now on the TikTok lives, ninjas?
It was testified to that they contract with TPUSA to film their events. This particular video, the state is going to, or seeks to introduce as Exhibit 8, was shown to Mr. Farnsworth. And that is the video that Mr. Farnsworth authenticates. He says that this is video that was captured by Visual Impulse cameras. And so with regards to authentication, I think the state has sufficiently provided the court with evidence to authenticate it.
And this is State's Exhibit 8. All right. I'm going to overrule the objection and admit State's Exhibit 8 as it relates to publication, citing to Article 1, Section 28, 1A, that this is Declaration of Rights of Crime Victims, and it states to be treated with fairness, respect, and dignity. And to those 2 points of respect and dignity, the court is not publishing this in the courtroom, nor is it being published, obviously, online. But the court will watch it in court. And again, to the parties, if you could protect your screens, however you choose to, and then I'll check to see when we're ready, and then we'll
Okay, it looks like they're going to play the full thing here, but they're not going to show it, obviously.
have it played. So turning to defense, is more time needed to? Okay, thank you. Turning to the state, to your screens. All right, all right.
Oh, so we're not in the top 100? That's BS, bro. How are we not in the top 100 with like almost 500 ninjas in here? How's that even possible?
Indeed, I see a head nod, yes. And let's go ahead and play this video only on the monitors, and if there's sound associated with it, the sound to be played as well. You may proceed.
All right, no audio. They're taking audio out. They're playing the shooting. So I'm in the 99 percentile. There's it. Yeah, no audio, chat. They're playing the video. Okay, we're ranked 93 in the world right now on TikTok. Nice. Sweet. We're number 3 right now. Guys, keep tapping the like button while we wait for this thing. Yeah, dude, we're literally yeah, they're showing the shooting, guys. Obviously, it's very graphic. So yeah. That's what they're doing right now. They're playing.
Remember the SBI?
Yes, the campus itself, UVU, is very well equipped with cameras throughout, and they were willing to work with us to provide video from those cameras, and so that was collected as part of the investigation also.
With regards to the UVU surveillance video, do you know if video was collected from there behind where Mr. Kirk was?
All right, guys. Brett's on it. He's going to start modding you guys up. I told him to cross-reference you guys in the OSS thing, and yeah.
Seated at the time that he was shot?
Yes, I'm aware that under the Hall of Flags, there is I'll refer to it as a breezeway, but a way for people to move from one side into the amphitheater, walking underneath the Hall of Flags. And I know there was a camera situated in that location.
Okay. And do you know, with regards to that camera view, well, let me ask you this. So that particular camera view, there was surveillance that was provided to you or another agent from UVU?
Correct.
Okay. And do you recall who provided that video to you initially and who collected it?
Initially, I don't know specifically for that video, but I know that whole process was...
Oh, it says I got you guys, bro. You guys are party number one. I literally been doing this all for you guys because you ninjas rock with me, I rock with you. So we're getting all you guys wrenches right now. That's one of the benefits of being an OSS, bro.
Was overseen by Mr. Olson, who's responsible for that system.
Okay. Do you have a first name for Mr. Olson?
Curtis Olson.
I'm sorry?
Curtis Olson.
Okay. And do you know what Mr. Olson or Curtis Olson's position is at UVU?
I believe he's a director.
Right. Is it his job to basically gather and forward any video that's captured by UVU?
He has a long title, but I think it's Director of Infrastructure, but he is responsible for that system.
Okay. With regards to this particular video, the video from underneath the Hall of Flags, what, if anything, have you done with that video in preparation for today's hearing?
I went specifically to meet Mr. Olson, have him review the video that we had. And again, like with the others, I had him complete an 1102 statement for us, describing his role and verifying the videos. I did that actually on July 2nd of this year.
July 2nd of this year?
Correct.
Oh, recently.
Okay. Give me just one moment.
Actually, I'm going to correct myself on that if I can refer back to my notes.
Okay.
All right, guys, I am getting off of YouTube and Twitter, okay? YouTube and Twitter going down. YouTube and Twitter going down, guys. Come on over. I dropped the kick link in there for you guys. We're going to continue on with the lead investigator. We're going to keep doing, breaking down this trial. Twitter and YouTube are going down. Come on over to Kick, kick.com/MyronGainsX, guys. It's going down now. Switch on over, man. Kick.com/MyronGainsX. YouTube and Twitter are both going down. YouTube and Twitter both going down. Everyone come to Kick.
Please, yes. Your notes you have there with you again?
Yes.
And referencing them will help you refresh your memory?
X going
It will,
down.
yes.
Okay, so don't read from it out loud. Just look at it and let us know when you've refreshed your memory.
Apologies. July 2nd seemed a little bit too soon. It was June
X
24th
going down
when I
now?
met with Mr. Olson.